Hi, everybody. It is Friday, April 25th. This is our weekly recap of everything that happened in Karen Reed's retrial. It's week one of testimony. I'm joined by Katherine Loftus, our legal analyst. Thanks for
Hi,
joining.
Kristina. Hi, thanks for having me.
So I think we'll go in chronological order.
Okay.
Obviously, you and I talk every day, so we've discussed a lot of this, but this is kind of the one place for it all to be together.
Yep.
So let's start at the beginning. Let's start with opening statements. We had Alan Jackson for the defense, Hank Brennan for the Commonwealth. These are two different attorneys and gave openings last time. What were your takeaways?
I thought they both did a pretty good job. I mean, they were different in ways, not only substantively, but the way they present. Every attorney is different in how they like to talk to the jury, how they like to present their evidence. I thought Hank Brennan did a really good job. He seemed to me to be more of sort of the old school kind of style of lawyering. He didn't have a podium. He did have notes on the table that he looked at occasionally when he glanced over, but didn't have them in front of him. Really just kind of outlining this sort of narrative story to the jury. And I think he hit a lot of points about things that we didn't hear last time, or maybe weren't really focused on as much in trial one. He talked a lot about the data points, the new information we're going to hear relative to Karen Reed's Lexus, and John O'Keefe's cell phone, the battery temperature, things like that. There were some things that he left out that I thought might have been helpful for the Commonwealth to address on the front end, which was the police investigation, Michael Proctor, really not even addressing that at all. I think left a little bit of a hole for then Attorney Jackson to come in and spend much of his opening statements focusing on Michael Proctor.
So maybe the prosecution should have acknowledged a substandard investigation in their opening.
I think so. I mean, and I thought that was potentially what he was going to do. And, in ways I understand why you don't want to start off with, bad news for your case. But at the same time, if you know for sure that the information is going to come out, it always helps a little bit to try to soften the blow. But nonetheless, I think overall he did a good job. And Attorney Jackson the same way. I mean, Alan Jackson is he's a very, very good attorney. He's a great storyteller. He knows how, to use tone and inflection, where to pause. He's very good at what he does. One of the phrases he used when he was talking about Michael Proctor in the text, he lowered his voice and said, shh, like he's one of us. Things like that are very effective to a jury. Because it causes them to pause and really pay attention to that. So as always, and as with last trial, I think he did a good job. I do think in some ways there was over promising, which is similar to what happened, I think, in the first trial with David Yannetti. For many who remember, he came right out and said, Karen Reed's being framed. Alan Jackson didn't say that, but he sort of skirted around that issue. And he directed the jury to focus on, data and, what he said was science and eyewitnesses that were going to show that John did in fact go into the house. And so I'm interested to see if they're able to develop that. I don't know, based on what we saw in trial one, where that information would come in through any, eyewitnesses. But overall, I think the two clearly painted two very different pictures of what they believe happened that night. But they were equally persuasive in their own way.
Yeah, I do want to ask you, because a lot of what we've talked about is obviously now we're in the Commonwealth's case, right? So everything this week has been led by the Commonwealth.
Right.
That cell phone battery data you and I talked about, from my memory, that was really the newest or only new evidence that I heard of in the opening. Can you talk about that?
Yeah. So with the cell phone data, so what he referenced was that when John was allegedly still in Karen's vehicle, it was at 77 degrees. And then within, a certain amount of time, it dropped, I think, to 70, then 60. And it might have been 50 eventually at some point. But basically, it began to drop as John O'Keefe got out of the vehicle. And and in addition to that, I don't believe we heard really extensively about the Waze data the last time. That was one of the things that Attorney Brennan mentioned in the opening. So what he's trying to do is use the data to really triangulate it and show that the Waze data, the Apple Health data, the phone temperature, the Lexus data, that it's all going to come to this one sort of time and space. in which they're going to say, see, all of the data brought together shows that there's no way he went into the house. You know, the fact that the cell phone battery never raised the temperature, that the Apple Health data didn't move after, 12:32, things like that. So that's the first we heard of it. We never heard about the temperature of the battery the first time. And I don't know if it was available to the Commonwealth and they just didn't use it, or they didn't have it, or if this is through a new analysis, but I'm sure we'll see how that comes in.
On the defensive side, I was curious about your thoughts on this, because you had kind of predicted they might go more towards the bad investigation defense and less towards the third-party culprit defense. Is that what you've seen so far?
No, that's not what I've seen. That I've seen them go more towards third party. I mean, to me, obviously, there's only a few witnesses, so it's difficult to really understand what their full theory is, and they were always going to use third parties, so it's not that they were not going to point the finger. But I think this idea of, Alan Jackson talked in his opening statement about when some of the interviews with firefighters were done, one being Katie McLaughlin, I think, and that, somebody else's was set up by Kevin Albert. So that was sort of cluing the jury into, hey, somebody in the Albert family potentially sent this up. So like maybe we think about that those statements, can't be relied upon. So right away, like sort of the third party is lingering. And then it came out sort of full throttle with Carrie Roberts, in which what they're trying to do is not really impeach the credibility so much of Carrie Roberts. They're trying to say to the jury, this woman was influenced by Jen McCabe, who told her a lie, and it snowballed from there. So in a strange way, the aggressive cross-examination of Carrie Roberts really wasn't for her. It was more so to point the finger at wait until you hear from Jen McCabe, because you shouldn't rely on her, and she sort of tainted what Carrie said. So it seems to me that they're focusing so far more on third party, and that Jen McCabe is going to be like the sort of mastermind of it all.
Okay, so we'll get to Carrie Roberts in a minute. I kind of want to start, I'm going to lump together two witnesses, firefighter Timothy Nuttall and then firefighter Daniel Whitley.
Yeah.
And then actually even the firefighter who testified today. So this is over the course of several days. Jason Becker, I believe his name was.
Yeah.
These are all paramedics who responded. The first one, Nuttall, he responded to actually help resuscitate John and rescue John. The other two responded shortly after for what's known as a Section 12, a psych call to transport Karen Reed because she had expressed suicidal thoughts. I'm curious about your takeaways of the purpose of the testimony of those paramedics, as well as the cross-examination of them.
So the purpose of the testimony is not only to sort of set the stage for what the scene physically looks like, what obviously we heard a lot about the weather the first time, but it's a part of the case that has to be considered. And so I think Attorney Brennan is doing a better job at introducing it, like not so, sort of as a secondary, asking everybody, what was it like? What was, the weather like? How was the ride there? Things like that. So he's trying to set the physical scene for the jury and what it looks like. But what he's also trying to show is that there were multiple statements made by Karen Reed to various individuals, and that these people don't have anything to do with the case. They're not related to the Alberts, they're not related to the McCabe's. They literally just showed up as a result of a 911 call, doing their jobs. And they don't have they don't have a motivation to lie or to make something up or, act like they heard something that they didn't. So, the cross-examinations of the firefighter medics overall, I think has been a little aggressive. There's a line with cross-examination where your goal is, even if it's a likable witness, you can get them to say things that are beneficial to your client. And obviously, Alan Jackson did with Timothy Nuttall, was able to catch him in these inconsistencies. Yeah. And, ultimately, the interesting thing is, that we're focusing on, did you hear it 2 times or 3 times? Does it really matter substantively in the end, even more so because Miss Reed has admitted to saying that
is I hit him, or I hit him, I hit him.
Right. And so there's no, you're not going to get out of him that he didn't hear it at all. He's pretty sure that he heard it at all. So the continuous question, I think at some point after you've gotten the inconsistent statement out through the witness, when you continue to cross-examine so aggressively, sometimes you lose sort of the win that you got, with them admitting that they weren't consistent in their previous testimony with today's testimony, because then the jury starts to feel bad for them. You know, they start to look at them and say like, well, this is just a guy who showed up as a result of a 911 call. Like, this isn't an individual who's intimately involved, you know, sort of in this story. So I thought it was a little bit aggressive, but they certainly scored some points with some of the inconsistencies.
Okay, so let's move on to Peggy O'Keefe. This is John's mother. She did not testify last trial. She did this trial pretty briefly, and then there was no cross. Alan Jackson just said, "I'm sorry for your loss." So what did you think about her testifying? And I'm curious if you think she was a substitute for her son, who testified Paul last trial.
I think so, because they really mostly could testify to almost the exact same thing. I mean, aside from, you know, getting the original calls in the morning and who called, you know, Paul versus who called Peggy, really they're going to be talking about the same thing, what they observed at the hospital, you know, the initial sort of seeing Karen when they were back at John O'Keefe's house, and Karen and her dad and her brother came in. So they really could testify to, you know, most of it would be similar. And one of I think the goals probably of Hank Brennan this time around is not to present as much duplicate testimony. Sorry, I lost the word for a second, because it can become monotonous if you have multiple witnesses saying the same exact thing and you don't need to really confirm that. Overall, I thought she did a good job. I mean, clearly to me, she was very emotional. She was nervous being on the stand. I think Attorney Brennan didn't want to push her too far. And I thought it was obviously the right decision for the defense not to cross-examine her, because even if you could substantively get something out of her that would help your defendant, you're just going to look, you know, you're not going to look good in front of the jury cross-examining the, you know, the mother of the victim. So overall, I thought it was effective in sort of portraying who John was and what the background was, and his sister, and the current situation now. And ultimately, it led up to the reason why Hank Brennan wanted to play that clip from the documentary about what Karen said that Peggy O'Keefe said. You know, he looks like he got hit by a car, which she denied saying. So that probably really was the most important piece of her testimony.
Okay, so let's go kind of out of order now, and we'll get back to the other witnesses, but let's talk about Hank Brennan's strategy. So we talked about this a little bit. So far, it seems as though in between every witness or most witnesses, he is, for the jury with no witness on the stand, playing a clip of a relevant portion of one of Karen Reed's many media interviews. So far, it's been about whether she said, "I hit him," her conversation with Peggy O'Keefe, and how much she had to drink that night. What do you think about this strategy?
I mean, I think it has to be pretty effective to the jury. And it's so, Kristina, honestly, it's so unusual for this to be happening, to have this many statements of the defendant that were just so freely given. I mean, it's almost in a crazy way, it's almost like a gift to the prosecution, because you don't usually, most criminal defendants, you know, assert their right not to self-incriminate themselves. And instead what's happening here is, you know, this isn't just one media interview in which, you know, you might get a clip here or you might get a clip there. I think there's somewhere between maybe 40 and 50 clips that Attorney Brennan intends to admit. So if he's sort of peppering every few witnesses with one or two slides of what, in Karen Reed's own words, said, you know, this is my testimony, the difficult thing for the defense is the only way to rebut what she says in those clips would be to put her on the stand, and they can't
want to do. Right?
They can't put her on the stand because she can't be subject to cross-examination on this. There's just way too many inconsistencies. It would go so poorly for her, and so that's the problem. They have really created a new strength in the Commonwealth's case that now they can't rebut because she can't take the stand. So it's going to be tough as her attorneys to be sitting there knowing that they, on their advice, you know, she spoke and gave these statements that, you know, are making the Commonwealth's case stronger against her.
Quickly, let's get to the legal issue here, which a lot of people have asked me on social media, like, why is this allowed if she wasn't under oath? Why is it allowed?
So you don't have to be under oath for a statement to come in. You don't have to be, any statement, theoretically, it doesn't have to be under oath previously to come in, whether it's in a video or whether, it's written, things like that. It has to go through the evaluation of the hearsay process. So we decide whether statements are hearsay, if they're not hearsay. If we think they are, then we go through the list of what the exemptions are. Now, one of the main exemptions from the hearsay rule is statements of the defendant, or otherwise people might hear them referred to as admissions. And what that means is anything, I feel like I've said this a little bit ad nauseum, but it really means when they say anything you say can and will be used against you, they mean it. So if you speak and it has something to do substantively with what you're charged with, or it goes to, really the heart of the matter, the government is going to use those statements against you. So it doesn't have to be said under oath. It doesn't have to be, in court. It doesn't have to go through the hearsay analysis. It just comes in. It's just admissible. It doesn't even have to come in through a witness. It can just be played. And so that's why it's so, so many attorneys have really been raising sort of the alarm bells of how would they possibly let her do this, because they know they're not going to have an argument to keep these clips out.
Right. And you spoke in particular with me about having her do that discovery documentary series, which was recorded during the last trial, where she spoke very freely with the documentary crew. And you talked about your impression of kind of why she was so free with them.
Well, I think that, the only thing I can really rationalize is they were so convinced that there was no chance she was going to be found guilty or there was a mistrial. I think they had to have been so convinced of that in their core that's the only way as an attorney you would allow your client to do this. And, I think that in some ways goes to obviously the belief that they have in their clients, right? And they believe fully in her innocence. And so, from their perspective, it's, her telling her story. But as an attorney, even if you believe your client's innocent, that anything they say can be used in any way. You don't get to control how the Commonwealth presents it. You don't get to control how, it's used and in what manner. And that's why we always say, even if you want to talk, it's better not to, because it never ends up helping. So what has really happened from the documentary series, really all of her media interviews, but the HBO ID documentary the most, I think, is it's persuasive to the public in looking at the case and analyzing the case from sort of an outside social media perspective. It's very damaging to a jury to see that played in court. So we have really two different outcomes from it. It's good. The perception of it in the public realm is good. It's very bad in court.
Well, and there have been some elements of it as well, because you and I follow this so closely. So we've seen all of these interviews. There have been elements played that were not aired. Like, for example, there was an off-the-record conversation with Gretchen Voss where Karen Reed, this for Boston Magazine, Karen Reed described showing Jen McCabe and Carrie her broken tail light, which is something she's since denied ever doing, talking about picking out broken pieces of the broken tail light. And then a clip from the HBO series as well, where she talks about how she, in her own words, she shouldn't have been driving that night.
Right. And so we've already heard multiple pieces of information that weren't in, because obviously whoever's making the documentary or writing the article, they're going to pick what they want for their story, which is how it works. But when Attorney Brennan subpoenaed the records from, both Boston Magazine and HBO, you had all of this background, interviewing, not only they didn't get the notes, but they basically got everything else. I think with HBO is hundreds of hours. And we heard the producer of that documentary did some interviews in which she said there were parts in which the defense said, can you not include that? Like, don't use that clip after they filmed it. So there were things that they knew while filming that could potentially be problematic. But I think still, because they were so, they were really so optimistic that she would be found not guilty, I think they were a little blinded in their analysis and given her advice to talk.
Okay. I have two more topics. Three more. Let's talk about Trooper Nicholas Guarino. He's here in a different context compared to the last trial. He's going to be recalled as a witness multiple times, so he's already been on the stand twice. Can you talk about kind of the role he's playing?
So he's basically, what his job was, obviously we had a little bit of direct examination with him in which he described the, the data, how a phone, gets to his possession, what the process is, whether he's involved in the investigation. So we sort of laid the foundation for that. And then the text messages between Karen Reed and John O'Keefe were introduced through him. And basically his role throughout the trial was going to be what we call a reader. The Commonwealth had originally asked for independent readers, a male and a female, to basically do like a back and forth retelling of the text messages. That wasn't allowed by the court. So Trooper Guarino is basically, every time he's called, he's reading the text messages back and forth between Karen Reed and John O'Keefe. And because Attorney Brennan wants them introduced at different parts of the trial, that, because what he's trying to do is use the text messages in sort of in the middle of testimony where the timeline that he's presenting, right? So he doesn't want all the text messages to come in because some of them will be sort of out of order, which means that Trooper Guarino has to keep coming back in over and over until the text messages are done. And many people had questions about why he's not being cross-examined. So that will wait. Basically, the defense has the right to cross-examine him, but because he's just reading them into the record, there's not really anything to question him on. So what they'll do, if they want to question him at all, we'll wait till the end. So that you've heard Attorney Alessi a couple of times say, we reserve the right to cross-examine, and that will be likely when the last time Trooper Guarino is called.
Yeah, and you point out the fact that he has to come back. I mean, this is also an indication of the different timeline that this trial is being presented. Like Adam Lally went in chronological order, and
right.
It does not.
Right. No, and it's interesting. And, it's when we have these big trials, the first couple of days is like trying to figure like, okay, which way are they going? How are they going to present it? And I wasn't entirely sure at first, but I think I see where the Commonwealth is going, and that, they know this is going to be a long trial, right? So if we're at, 5, 6, 7 weeks, wherever we end up, the information that's important at the front end, you want to be able to have the jury remember that 7 weeks down the road. And the way you do that is sort of, instead of doing everything all at once, you sort of sprinkle it all in. And so what he's doing is he's sort of, for almost like each scene and each act, he's using, 5 or 6 witnesses to sort of set the scene here. And then I think he'll do the sort of next set of witnesses, and those witnesses will confirm some of the things that were said by the people in the first, and so on and so forth. So It's like little pieces of information that will trigger to the jury. Oh, that's right. We heard that from, Firefighter Whitley. Oh, that's right. We heard that, from, like, I think because Carrie Roberts and Jen McCabe this time are separated by more, by the time Jen McCabe testifies, they'll remember, okay, Carrie Roberts said that, and she confirmed what Timothy Nuttall said. So he's more, sort of like slow, he's in it for the long game, right? He doesn't just want to do it in chronological order. He's really trying to paint a broader picture of what his theory of the case is.
Yeah. I just want to mention, so that this is in this video, I don't know if we need to reflect on it unless you feel the need, that today a doctor from Good Samaritan Hospital testified that based on blood alcohol testing, Karen Reed's blood alcohol level after 9 a.m. in the following morning was like a 0.093.
Right. So that's still, so I mean, it's interesting. We heard this, he was the same physician from Good Samaritan in the lab who testified the first time. And so, we'll hear at some point about the extrapolation of the blood alcohol level. So what does 0.09 at 9 a.m. mean for, anywhere between 11 and 1 a.m.? 0.09 is still in and of itself over the legal limit. So anything over 0.07 is presumptively intoxicated. But the interesting thing about, the questioning, Attorney Little is the one who did the questioning of Dr. Fowler, and, really pushing back on the testing and the blood alcohol level and things like that, which at this point seems like I'm not sure what the goal of the benefit is, because I think the Commonwealth at this point has probably already proven intoxication. I mean, we have the clips from Karen Reed herself talking about how many drinks she had and that she shouldn't have been driving. So I don't think really pushing back on whether the blood alcohol was, 0.09 or 0.06 is going to have much significance, because it seems pretty clear that everybody was intoxicated.
Okay, let's get to what I think is my last topic for the day, which is who I'm perceiving based on conversation was the witness of the week is Carrie Roberts. I don't know if you agree with that, but can you just weigh in on her testimony?
Yeah, I mean, she was certainly the most hotly contested, I think, of the week, and
Yeah.
and the most. I mean, she was a really pivotal witness, I think, the first time, because she is somebody who, from the Commonwealth's perspective, and probably it comes across to the jury this way, is not connected to any of the individuals. Obviously, she is now.
Right.
But before January 29th, she really only knew these people as other friends of John. She didn't have her own personal relationships with them. She wasn't out drinking that night. She wasn't, with them at all. And so she really gets inserted into this situation, which what it does is it just gives an air of reliability as to what her testimony is, because she doesn't have any sort of motivation to lie. Now, on the other hand, we had pretty strenuous cross-examination of her.
Which it didn't last trial. She didn't get cross-examined.
No, she didn't get cross-examined at all. And I think that's probably because in her cross-examination, there was reference by Alan Jackson to this interview that she did with police later, in which she was asked whether she actually heard that. Now, I don't know who that investigation was with. I don't know if that's referring to the federal investigation. I don't know if that's referring to
the grand jury hearing, you mean?
So she said, so there was later a point, I believe, you correct me if I'm wrong, when Alan Jackson was cross-examining her, he stated that she was later, after the grand jury testimony, she was questioned by police, and that she said she didn't hear it independently. And so what I inferred from that was that they didn't have that report last trial. So I don't know where that report has come from. Let me just
finish our viewers for what she's hearing that we're talking about.
Yep.
In the grand jury hearing, Carrie Roberts had said that she heard Karen Reed ask Jen McCabe to Google hypothermia, which is correct. A critical piece of evidence for the defense's case, whether it happened at 6:23 in the morning or 2:27 a.m.
That's correct.
But then on the stand this week, Carrie Roberts said, no, I didn't actually hear it. I learned of that later.
Right. So she testified incorrectly in the grand jury, for sure. I mean, there's no doubt about that. 100% he caught her in that inconsistency. The question is, what consequence does that have? Because ultimately the question is, okay, so she heard it instead of hearing it herself. We're going to hear from somebody else, Jennifer McCabe, who says she'll be the one to testify. Obviously, that's going to be contested as well, because she's really one of the individuals in this case who really is focus of it in her actions that day. So, I thought that it was a win in terms of, it's always a win when you can get, as a defense attorney, it's always a win when you can have a witness for the Commonwealth admit that they were wrong, that they said something incorrectly, that they didn't actually hear what they heard.
I mean, Alan Jackson, at this point, you lied to the grand jury.
Right. Yeah. And I think that, it's the problem. There's a lot of talk about this, idea. She said, we made this timeline together. Peggy O'Keefe asked us to sit down. So we sat down and made it, and it's too complex of an issue to really go into, in this format. But I think it's something that comes up in a lot of cases is, people's memory and what memory really is. And I think this is the problem sometimes with talking with other people, is that you have this memory and sometimes it's, did I hear that? Or did I think I heard that because I heard the person who was with me say they heard it, and it gets, over time, we're talking 3 years now, some of those memories get mixed. The next question of the analysis is, okay, if we prove it's not her memory, does that mean the memory, the underlying substance of the assertion, which is that Karen told Jen to Google at 6:30 in the morning, does that mean that's wrong just because it's not your memory? No. And that'll be the subject of Jen McCabe's cross-examination about whether she actually asked that or not.
didn't it seem like a lot of the cross-examination of Carrie Roberts was, yes, about her inconsistent statements, but almost trying to show that maybe she had been influenced by Jen McCabe this whole time?
Yes. Yeah. And that's why when we were talking about it a little bit earlier, is that really the cross-examination to Carrie wasn't about Carrie.
Right.
It was about, it was, but it was trying to make it look like, oh, Carrie was told what to say by Jen McCabe. And that's really, you didn't have this independent information, but you spent all the time with Jen McCabe. You were with her before you had the interview with the police initially, on the next day, January 30th, I believe it was. You spoke with her this week, you were friendly with her before the first trial. So basically what the defense is trying to get the jury to, infer is that you can't really rely on what Carrie Roberts is saying, because there's a bad actor who's been by her side the whole time, sort of whispering in her ear. So not only should you not consider her testimony reliable, but wait till we get to Jen McCabe and you won't find her reliable either.
Okay. The very last thing, let's try and cover this in less than a minute because I'm way over time.
Yeah.
Is the jury got to go on a view this week, meaning that today, they got to go to 34 Fairview with the attorneys and with the judge and just look around. And also Karen Reed's Lexus was there. It was missing its taillight, completely pulled out, and the jury was warned that that's not the condition. It was actually in, the taillight's now in evidence. What's the importance of a jury view?
I mean, it's helpful just to establish what the scene actually looks like, because all of us know that a picture is not the same as seeing something in
Right.
person. It's just not. And so because the scene is so important, exactly where the pieces of taillight are found, exactly where John O'Keefe's body is, the moving of the Lexus back and forth, where the second floor window is, which is what Attorney Nettie was pointing out. All of those things are going to be mentioned over and over, not only in testimony, but in the physical, evidence, which is photographs, videos. So it helps the juries just sort of get an understanding of, oh, right, that's when we were in the view. This is where the vehicle was, or this is where the body was found. It just gives them a little bit more of like a tangible aspect to what they're seeing in court.
Thank you so much. I will leave
Thank
this
you.
little nugget for our viewers who watch this case or watch our coverage. We don't get to know as reporters who's coming up next as a witness unless it's mentioned in open court. However, I will say that I had seen sitting in the hallway ready to be the next witness one of Brian Albert Jr.'s friends who was in the home that night. So
The same. Maybe first thing Monday morning.
That might be who we
start off with a bang.
Monday morning. So thank you as always. And
Thank you.
we'll see everybody next week.
All right. Have a great weekend.
Bye.